If you are a probate executor, I got to tell you, it is a thankless job with a lot of work. However, it has to be done. And if you end up being the personal representative, the PR of the estate, and you have property to sell, this is the right video for you. Now, I'm not going to go on a real deep dive about the entire probate process and all the intricacies and the ins and outs. This is just a global overview of what to do if you are a PR and you have to sell a probate property. Probate is the legal process of administering a deceased person's estate. If you've been named executor, your job is to manage the process, which includes paying debts, handling the will, and ultimately selling any real property. In your case, maybe mom or dad passed, a sibling, family member, uncle, aunt, cousin, or just a friend, and maybe you've been named to be the executor of the estate. If there's no will and nobody was named to administer the estate, then somebody has to step up, take the reins, and go through the probate process. If there is no will and the decedent didn't leave any instructions on who's going to handle his affairs afterwards, that person becomes the administrator, and they have to petition the court in order to become named administrator of the estate. So the first thing you need to do is hire a good probate attorney. That's crucial. Going through the probate process can be daunting and very confusing, not to mention time consuming. I told you this was a thankless job. One thing I want to mention to you is that there are statutory fees that the attorney receives for doing the probate process for an estate. So they're not going to charge you hourly or anything like that, or one flat fee. The courts determine how much the attorney is going to receive. By the way, if you are the executor or the administrator, you are entitled to the exact same statutory fees. So you will be compensated for all your time and energy and effort in going through the probate process. Let's go over those fees quickly so you understand how much the attorney is going to get and how much you're going to get. So I'm going to read what ChatGPT had to say about this. Okay. In California, the executor or administrator of a probate estate is entitled to statutory fees similar to those received by the probate attorney. The fees for executors and attorneys are set by statute and are calculated as a percentage of the gross value of the entire estate, not just the property. So in California, the first $100,000 of the estate, the attorney and the executor receive 4%. The next 100,000, they receive 3%. The next 800,000, they receive 2%. And the next 9 million, they receive 1%. So there's a sliding statutory fee schedule. Let me give you some examples. For $1 million estate, the total executor and the total attorney fees are each going to be $23,000. For a $1.5 million estate, the total executor fees are going to be $28,000. So that's how the statutory fees work. Now you know how much the attorney is going to get, how much you're going to get for administering the estate. Okay, now that you have an attorney, he or she's next job is to file the petition for probate. Here's what it looks like. And any real estate in the estate will be listed here. It's called the DE-111 petition for probate. So in that petition, they're going to be naming the attorney, who the executor or administrator is going to be. Any real property or other assets get listed on this petition for probate. So once that's filed, the family members and all debtors will be notified by mail of the impending probate process. In a few weeks, there will be a court date scheduled. The attorney is going to petition the court for a court date. And the court date is to petition the court to name you as the executor or administrator of the decedent's estate. Now, of course, family members can object to you being the executor if there's no will and the decedent didn't tell anybody who they wanted to administer their estate. That's called dying intestate without a will. So once the family members get notified, they can object. Somebody else can file a competing petition. It can get nasty and ugly if there's no will and there's no agreement. Now, obviously, if you were the only child of a parent, it's very easy to get appointed as the personal representative of the estate. So now let's assume that nobody's objecting to you being the administrator or executor. What you're waiting for from the court are something called your letters. And letters testamentary are for executors when there's a will. Letters of administration are for administrators of the estate when there is no will and you're seeking to be appointed as the PR for the estate. Now, one more important thing I want to mention is the Independent Administration of Estates Act. It's called the IAEA. Let me read what ChatGPT says about the IAEA. The IAEA is a key regulation that provides a simplified probate process in California. Here's a breakdown of what it offers. It offers the executor or the administrator of the estate to handle many actions like selling real estate without needing court approval, making the process faster and less costly. If you have full authority, that allows the executor to sell the property with minimal court involvement, including selling the property, paying debts, and distributing the assets without judge's approval. If you have limited authority, that requires court oversight. You'll have to get court approval for selling real estate. There's going to be a court overbid process, and the buyer will ultimately need court confirmation. With the Full Authority Act, you don't need court confirmation. You can sell the property directly once you have your letters testamentary. So using the IAEA effectively can speed up the process, reduce legal fees, and make managing the property and selling the property more straightforward, especially with real estate involved. Make sure when you talk to your attorney, you tell them you want to go through the Independent Estates Act and you don't want to have limited authority. You want full authority. Now, if there's a contentious situation with family members fighting and they're objecting and they're filing their own petitions, you probably are going to have to go with limited authority and have the court sell the property in an overbid situation. So you'll have limited authority in that situation. But if you can, tell your attorney you want the Full Authority Independent Act so that you can easily sell the property without a court overbid process. It's going to save you a lot of time and hassle, trust me. Now, let's talk about the selling process for a probate home. A simplified process is like this. Let's say somebody passes. You go to the house, you have the keys, you look around, you make sure everything's copacetic, make sure everything's locked up. Once you have your letters, you can start clearing out the house. What I recommend for the family members is go to the house and remove everything of value, everything you want, pictures, mementos, whatever. Take it all out, any valuables, etc. Whatever is left, furniture, clothes, stuff like that, that is generally going to be tossed out. There's very little value to used clothing, used furniture, etc. Maybe they had some fancy antiques or something like that, depending on the size and cost of the house. But generally, when we go to a house and the family removes everything, that stuff is usually tossed. So if the house is in decent condition and with a little bit of fix-up, you can get full value for the property, I would recommend that we trash out the house, take all the stuff out, every little bit, sweep it out, clean it out, and then you can start the facelift process. So painting, putting flooring in, or cleaning carpets, or replacing carpets, or putting new vinyl flooring in, fixing everything. I don't usually recommend, putting new bathrooms and kitchens in if the house is in decent condition. Just leave it as is. Just make sure everything's clean, it's painted, it's cleaned up. You might have to replace some window blinds or drapes or something. Make sure the landscaping's done, the grass is cut, the bushes are cut back. If you have overgrown trees, get those trimmed up. Just bring it to an acceptable standard that can be sold close to top dollar. So once all that's done, you're ready to put the property on the market. Now, if it's a severe fixer, if it's a hoarder situation, you're not going to be spending money to fix it up because you're not going to get any money out. At that point, what I usually tell a seller, a probate PR, is look, this property is not worth being fixed up by you. You don't want to spend $100,000 in 6 to 8 months hiring contractors to get it in shape. You want to sell it as is to a cash investor whose business is buying these properties, fixing them up, and selling them for a profit. Those buyers will generally do their own trash out after they own the property. You don't need to do that. So it actually makes it easier to sell a hoarder property. Now, obviously, you're going to have to hire a realtor like me, who is a probate specialist, to sell the property. Make sure he or she is familiar with probates, knows the court process, knows how to work with attorneys, knows all the different forms that you have to use to sell probate real estate in California. So assuming you have a good realtor who knows probate, you can either get the house fixed up if it's in good shape, or just take everything out and leave all the trash and refuse and junk in the property. Don't do any landscaping because we're going to sell it to an investor. Okay, so assuming you have full authority, once the house is fixed up, you've taken all the stuff out, you can put it on the market. It's going to be like a normal sale. You're going to put the sign up. You're going to put it in the MLS. You're going to market the property. Your broker's going to let everybody know in the MLS and in marketing stuff that this is a probate property. If you have full authority, the realtor is going to publish the fact that this property does not have to go to court, which is good for a buyer. And it'll just be a normal sale with the addition of a few extra probate documents that we have to fill out. If you don't have full authority and it has to go to court, your realtor is going to publish all that information in the MLS and the marketing pieces, and they're going to tell everybody this is a probate. Their seller does not have full authority. It is going to go to a court overbid process. Okay, so let's talk about that process if you don't have full authority. Now, once you get an acceptable bid on the property, you're going to notify the attorney, and the attorney is going to notify the court that we have an acceptable offer to go to court with. The court is going to set a court date for other people to overbid on the property. Once you have that court date, it's going to be published. The realtor is going to publish the court date in the MLS and marketing materials, and letting all buyers and agents know, hey, this property is going to court in such and such date. Now, there is a statutory overbid price that's going to set the first overbid for the property. In California, the first overbid for a probate property is set according to a specific formula. The court sets a minimum overbid of 5% plus $500 for the first overbid. Subsequent bids will typically be set by the court, usually $5,000 to $10,000 per bid, depending on the property's value and the judge's discretion. At the court, the winning bidder will put up a 10% non-refundable deposit into escrow once he or she is the winning bidder at court. Now, at this point, it becomes a normal escrow. But if the buyer doesn't close, they will lose their 10% non-refundable deposit. So let's talk about once the property is closed to escrow, what happens to the sales proceeds? In California, the sales proceeds are handled carefully to ensure they are distributed according to the wishes of the decedent or state law. Here's a step-by-step breakdown of what happens to the sales proceeds. Obviously, during escrow, any mortgages get paid off, any state or federal tax liens get paid off, or any other liens on the property, like for a solar system, get paid off first from the proceeds of the sale. Of course, all the court costs are going to come out, the filing fees, court costs. Your attorney's fees are going to come out of the sale proceeds. And your executor or administrator fees will also get paid out of the sale proceeds of that escrow. Also, any credit card debt, medical bills, income or estate taxes are also going to come out of the sales proceeds. Now, if there's a will, the remaining proceeds are distributed to the heirs according to the decedent's will, giving specified amounts or percentages to the named beneficiaries. If there is no will, the proceeds are distributed according to California's intestate succession laws. Remember, intestate means no will, which determines the legal heirs, how much the legal heirs get. Spouses get the most. Children get the most. Then you got parents, siblings, cousins. So depending on who is still alive and what family the decedent has, those people will all be getting a percentage. Not all, but depending on the state succession laws. Once all payments are made, a final accounting is submitted to the court for approval. After approval, the remaining funds are distributed and the probate case is closed. All these steps ensure that creditors' legal obligations and heirs or beneficiaries are treated fairly according to the law and or the decedent's wishes. Congratulations, you're done. Now, again, this is a time-consuming and very labor-intensive process. You're going to be deluged with paperwork and decisions, and sometimes family members are going to be on your butt asking what's going on. And, of course, they all want to know, how much am I getting? Am I in the will or whatever? So it's a thankless task, but it has to be done. And if you're if you're listening or watching this video, you're probably an executor or administrator that has this thankless task of administering the estate and selling any real property. But hopefully this video gave you kind of a global overview of how the process works and what you got to do to sell property. Again, I'm not going into deep detail in this video. I'm just telling you the overview of how to sell a probate property. I've helped a ton of executors, administrators, trustees sell real estate through the probate process. I know the court system. I've been down to Stanley Mosque, LA Superior Court, downtown LA, many times for court overbid processes for my probate listings where the executor didn't have full authority. I've worked with tons of probate attorneys. I know all the forms and everything. I'm a master at probate. If you have questions, reach out to me. I'm happy to answer any questions, help you in any way, give you any tips. I can, price a probate property and tell you what it's going to sell for within a few $1,000s. I've been doing this for 39 years. I can help you. I look forward to talking to you if you are an executor or an administrator. Thanks for watching, everybody. This is Derek Ruiz. Talk to you soon.